This podcast is brought to you by Customplan Financial Advisors, Inc., an independent insurance managing general agency in Canada. Financialpodcast.ca was developed with one goal in mind: to educate Canadians on important topics that affect their financial well-being and make it readily available to all. We welcome you to plug in and learn with us. If you have questions, please email us at contact@financialpodcast.ca.
Hello and welcome to the Financial Podcast. My name is Gary Poyer. The Financial Podcast is brought to you by Customplan Financial Advisors, an award-winning managing general agency that provides exceptional support and resources to the independent financial advisor. Please visit customplanfinancial.com to see all the resources that are available to you as the independent financial advisor. Today's podcast will be both interesting and cautionary, as we'll be reviewing some mistakes people make when they try to do estate planning by themselves. And to help us understand why do-it-yourself estate planning is risky, I'm happy to say that we have with us today Shannon James of the Calgary law firm Carscallen LLP. Shannon, welcome to our podcast.
Thanks so much. Thanks for having me.
Well, actually, Shannon, it's welcome back because you were a guest back in May when we discussed personal trusts. So, Shannon, maybe take a few minutes, refresh our memory as to what your background is and maybe a little bit about Carscallen.
Sure. So my personal background, I am a litigation lawyer and I practice primarily in the area of estate and trust disputes. So that would be anything from issues under powers of attorney, dealing with other people's property, or what happens with your property after you pass away. I practice out of the Carscallen law firm in Calgary, which is a full service Calgary-based law firm, really entrepreneurial minded, and we like to serve clients in the Calgary area and beyond with a huge variety of issues, not just the estate type.
Okay. How many lawyers are there in Carscallen?
Yeah, we have about 35 lawyers in our firm, practicing in all kinds of different areas, from corporate law down to litigation to family law and more.
Okay, excellent. Well, if anybody in our audience in the Calgary area needs a lawyer, you guys can certainly be of service.
Give us a call.
Okay. Shannon, we've all seen in movies or on TV, somebody going into a dangerous situation and they're busy writing their will out on a piece of paper or a napkin. Is that kind of will legal in Canada? And if so, what are the legal requirements in order to make it valid?
Yeah, so believe it or not, that actually is a valid will. We refer to that one as a holograph will. A holograph will is one that is entirely in the handwriting of the testator, so the person making the will, right. And it has to be intended as a will. So it sets out the person's distribution of their estate after they die. And so the really neat thing about this is that these wills don't even necessarily have to be on paper. And there's at least one Canadian case where somebody made a valid holograph will by scratching their instructions into the side of a tractor that had rolled onto the person in a farm accident.
Really? And
that was found to be a valid will. So this is a valid will, but the cautionary note that I would give is it has to be 100% in the handwriting of the testator. That's one thing that people don't often think about. It's not enough to print something on the computer, type it up, and then sign your name. It has to be all in your own hand.
In your handwriting, okay. And do you have to date it and sign it as well?
Yes, you should date. You absolutely have to sign it. It's not valid if it's not signed. And dating a will like that is good because what it does is it tells us, is this the last will? If you have another will, a more formal one, maybe with a different date, you'll want to compare which one is the last will of this person. So it's important to sign a date.
Right. And does it have to be, when you say handwriting, does it have to be actual handwritten, or can it be printed? Because from what I hear, kids don't learn handwriting anymore.
That is true. It seems they're not teaching cursive at school anymore. So no, it doesn't have to be in handwriting in cursive script. You can block print as long as it's entirely written by your hand. So your pen to paper, in whatever form of printing or writing you use.
Okay. All right. Okay. What about, or we've all heard of situations where an elderly parent, just for convenience sake, they'll make one of their bank accounts or their bank account joint with one of their children. So in a situation where there's only one child, Does it make any difference from an estate planning perspective?
So it does. And I'm going to pause for a second to say I absolutely hate this planning. The reason I do is because although it looks convenient on the face of it, and although it can be convenient, it can cause a whole host of problems. And not least of which is what happens to that property after you die. It's not lessened really by the fact that you have one child versus two or more, because when you make someone a joint owner of your property, when you put someone joint on your bank account, they have the powers of an owner. They can spend that money. They can use it. They can, if they're sued, they might have a judgment collected out of that money. There's all kinds of reasons that you still don't want there to be a joint account with somebody who you don't actually intend to be joint with. And for children, for adult children of a person who is doing this for convenience purposes, the consequences can be fairly significant. The unintended consequences can be significant.
Yeah, no, it sounds like it. I don't think a lot of people think about the creditor aspect. So that's an excellent point. What about in a situation where mom puts her daughter on the account, makes a joint, and the daughter is the personal representative, but there are other children. Does the daughter who's now on the account, does she have any duty, obligations, or anything toward the other siblings?
Well, she does. And I should pause again here to say that in Alberta, when a person puts their bank account or their property in joint names with their adult child, there is a presumption that applies automatically at law that they're doing that so that the adult child can hold the property in trust for the parent's estate. So even though people assume that being a surviving joint owner means it's theirs and they get to keep the property, the law presumes not a gift, but a trust in favor of the parent's estate. So in a situation where you do that, and the person the adult child who's also a joint owner, when they're also the personal representative, it falls to them to manage that property for the benefit of the beneficiaries in accordance with the will, if there is one. But that's true whether or not the person whose name is on the account is the executor. So the situation that you've described where the joint holder, the child joint holder, is also the executor, personal representative, as we call them, they have the duty to manage that property for the benefit of the estate, unless that child can establish that the parent intended to gift the property to them outright.
Okay. So whether the child is the personal representative or not, there's still legal obligation toward the other siblings.
That's right. They're placed in the role of a trustee over that property.
Okay. All right. So let's say that, mom gives or makes the account joint with her daughter, Sally. Upon mom's death, does Sally say, hey, mom made the account joint with me, here it is? How do the other siblings find out about it?
Well, that's part of the problem. This is one of many reasons that I don't like this planning and don't recommend it, is because the potential for things to go wrong is a little bit higher. So in the ordinary course, when a person passes away, when the bank receives notice, their accounts get frozen. They don't get distributed until the properly appointed executor, personal representative, confirmed by a grant of probate, comes along. Those accounts are protected and safe. In contrast, if you have a joint ownership situation, nothing formal needs to happen for the joint owner to carry on using that account. So if we had this situation where Sally is the surviving joint account holder, she's the daughter of mom passes away. If Sally is acting properly, she would disclose that to her siblings. She would say, my name is on this account. I'm holding it in trust for the estate. Mom put me on here for convenience. And Sally should disclose the money in the probate application. That doesn't always happen. And the temptation can sometimes be fairly strong for someone to just assume a gift. Now, the problem is when the siblings get wind of it, they are going to challenge it, most likely, and then ask that surviving joint owner, the child whose name was on the account, to prove that a gift was intended, not a trust.
Right. Okay. Shannon, what about the situation where you have an adult son living with his mother, and there's other adult children as well. And the adult son, being that his mother's elderly, persuades her to make her house joint. What recourse would the other siblings have against the son that made the house joint?
Well, so this applies kind of the same way as the joint accounts. So again, that presumption, we call it the presumption of resulting trust, where a parent puts property into joint names with their adult child. The presumption at law, which is rebuttable, the presumption at law is that the property is to be held in trust for the parent's estate. And when I say the presumption is rebuttable, what I mean is if the son is able to convince the court or establish that a gift was intended, mom truly did love me better and wanted me to have the house, well, then you've rebutted the presumption. Now, this situation, though, raises some other questions to my mind. And one of those might be the possibility of undue influence of son over mom, where son is exerting some pressure that comes from his special relationship with mom. You know, he lives with her. Yeah. He probably has a close relationship, to procure himself an advantage that comes at mom's detriment. So that's another little thing that would be lurking in the background for the observer, who would see this situation, which would cause questions to arise.
Yeah, because I could see the son making a claim. Well, you know, I shovel the snow, I cut the lawn, do all the maintenance. You know, mom said, because of all that, because of all those duties, here, have the house. But
yeah, and that is valid for a parent to feel that way. It's just a fact for a lot of us that there are people who help us out more than others, or that we just feel closer to more than others.
Right.
But I think, and it's my opinion, that when you're doing something like that, where there's a good reason, and there's no reason for it to happen early, put it in your will. Just put it in your will. And then you'll have the benefit of having spoken with a lawyer to get advice about what the consequences of doing that would be. Mm-hmm. You have a better chance of having your wishes upheld because you will have been informed of what your risks are and what the consequences of doing what you're doing are. And then there's also a record. There is a written record of what your intentions actually are. So I think a lot of these situations with proper estate planning can be managed. These concerns that people have in these special relationships that they want to reward, the better way to do it is still by a will.
Yeah. I mean, I can see, even in my own personal situation with my mom, one of my brothers and my sister-in-law are there where my other brother and myself aren't. And, my mom might feel obligated to give my brother some additional money, but going through the lawyer is always the best route. What about, and this is kind of similar again, but what about the situation where mom has a favorite child? And, when the child happens to visit, mom gives him or her some cash just out of the goodness of her heart. But she doesn't balance it out with the other siblings. She doesn't give them any money. Would the other siblings have any recourse at all toward the mom's estate, or is it too bad?
So that's an interesting question. There actually was recently a case of the Alberta Court of Appeal on a similar issue, where the question about a parent's pre-death gifting was raised. And the case that I'm talking about, it's called Duhn Estate, D-U-H-N Estate. And it's a very recent decision of the Alberta Court of Appeal. And that decision stands for the proposition that absent sufficient evidence of abuse, undue influence, or incapacity on the part of the parent, there generally isn't even an ability to go back and look at pre-death gifts. So if mom did have a favorite child and mom made gifts with full mental capacity to do that, free from undue influence, and without any indication of some abuse by the recipient child, it's kind of mom's decision. Mom gets to do what she wants with her property. Now, on the other hand, if you discover that something sneaky was going on, real suspicious suspicious circumstances backed up by evidence, and that part is important. It has to be backed up by evidence of incapacity, undue influence, or abuse, then you might be able to go back and look at it. But it's quite a difficult challenge, and the law does favor people's ability to stay private about their pre-death affairs.
Yeah. I mean, I can just see the situation where, let's say you have two siblings, and the one sibling lives in the same city as the mother, and the other one doesn't. The one in the city visits the mom, goes there for Christmas, Sunday dinners and stuff like that, where the one that doesn't live there doesn't. So mom wants to balance things out a little bit, gives the other one some cash in lieu of the dinners, I guess. But so, I mean, parents are parents.
Exactly. And I mean, the other thing to point out too is there's still an ability, if you want to make it very clear what happens after you pass, if you don't want gifts to be equalized on death, a well-drafted will can address that too.
Yeah, for sure. There's a myriad of situations that we could talk about that I'm sure you've come across. But what about this one? Let's say that the mother doesn't trust banks. And so whenever she gets her check or money's deposited into her account from the government, she goes into the bank branch, withdraws the cash, takes it home, puts it into a suitcase, hides the suitcase away. Her intention is that she's going to leave a letter that's going to be found after her death about this money. But let's say that upon her death, the first child goes into her house, starts snooping around, and finds the cash. Sneaks out, takes it home, and the other siblings say, well, wait a minute, this is unusual. This is weird. Why doesn't mom have an estate, some money? And they start investigating and find out from the bank that this is what mommy did. She walk into the branch, walk out with a wad of cash. What recourse do the other siblings have against the sibling that now has the suitcase full of cash?
Well, that is a tricky situation, and sadly, this or things like it happen far too often. Okay. You can sue that sibling if you have evidence to support it. So for example, let's say you have the doorbell camera that shows child number one coming into the house empty-handed and leaving with boxes of belongings. The first issue is going to be tracing it. And so you can go after that sibling. You can initiate a claim, and normally it would be the executor of the estate who would initiate that claim on behalf of the estate to recover any property that was removed. And in fact, that's one of the duties of an executor, is to bring in the property of the estate. But with these cash transactions, that can be very, very difficult to prove. It's unfortunate. There are still people out there who are distrustful of banks, who prefer to transact in cash. But it really does open you up to these kind of problems. Less and less, I think, as people become more comfortable with electronic banking and with debit cards and all of these things, but it is still definitely very much a problem we see a lot.
Yeah, I bet. It's sad how families can break up over money. One of the parents or the second parent passes away, and all of a sudden the fight is on.
That's tale as old as time.
Yeah, and that's why there's lawyers like yourself to help sort that situation out. Let's say that a father lends his daughter $20,000, and the daughter's struggling, so the father helps her out a little bit. But there's no documentation. If the child is the only child, does it make any difference if the father gives the daughter a $20,000 loan?
It does, I think. It may not, but it can. This can be important. So for example, let's take the situation where maybe when dad made the loan and he had plenty of money and everything was fine for him financially, but let's say things changed, and by the time he passes away, let's say he owes someone some money or he has debt. The fact of this outstanding loan that his daughter has, maybe she has to repay it. And maybe there are other people who are entitled to get at dad's money in the ordinary course. So that can matter. The other thing is there's sometimes tax consequences to forgiving loans. There's sometimes those sorts of issues. So keeping on beating the drum of having things documented properly, it really is a good practice for people, even within their family, to get some sort of documentation to evidence why they're doing a particular thing.
Yeah, that's a good point. I never thought about if the father had a credit card balance outstanding. The credit card company obviously wants to be paid, and if the daughter owes the father, they're going to want to get the money. So that's a good point. So if the daughter is not the only child, so then now let's say that there's other siblings, is it the same kind of situation? The siblings can go after the daughter as for part of their inheritance.
Well, that's a big problem, actually. This is something that can keep me up at night. Actually, when you think about it, you think loaning my children money, it's not going to be a problem. They'll always get along. That's not always true. So the nightmare scenario is, let's say you've loaned one child money to help pay legal fees, maybe whether they're going through a divorce, or to help them buy a house, or to help them get set up in their business. If that child doesn't pay parent back before death, they're in a position where they might say, no, I was never intended to pay this money back to mom and dad. It was a gift. And then the other siblings are going to have to turn around and try to establish that, no, this is a loan. You owe the estate. You owe us money. So if the intention is that you're making a loan to one of your kids, and it is a loan and it is to be repaid, it should be documented to help out your family. And also, a well-drafted will could address what happens to debts or advances made to kids during the parent's lifetime. So, this is really a nightmare scenario, because you're hitting people at the most emotional time of their life. The death of a parent is a highly traumatic event. And then to find out that you have a child who potentially owes the estate a ton of money, it really can bring on the fight. So without question, these things should be documented.
Yeah. Okay. What about a situation where the child has borrowed money from the parent? Okay, and maybe there's no documentation, but the other siblings know about the loan and they have documentation among the three. Okay, so acknowledging that the loan exists. Is that legal? Is that a good idea?
To have loan documentation?
Well, no, let's say that, I'll use myself as an example. Let's say that my mom lends me $50,000.
Okay.
But there's no documentation. But the agreement is that I'll repay my mom. My brother finds out about this loan from my mom, and then he comes to me and says, "Gary, I know about the money. Let's make an agreement that upon mom's death, you've already received $50,000 from the estate." Would that agreement between my brother and myself stand up in court?
Well, the question, I think the last time I was on here, I said it depends a lot, and I'm going to say it depends again. Okay. So the best evidence of an agreement with a parent is obviously the agreement with the parent. Right. You might be able to make an agreement with one of your siblings, but whether it holds up or not against, for example, a will that says something different, well, that's a bit of a debate. What you've agreed privately between your siblings doesn't necessarily bind your parents' estate. And the other comment that I would make on that is that the best evidence of your parents' intentions, or of the parents' intentions, is something from them. Because there's a rule of law in Alberta, a rule of law that says that if you're trying to rely on a statement made by somebody who is deceased while they were alive and it benefits you, you can't get judgment there without having benefit. It doesn't have to benefit you even. If you're going to try and rely and get judgment on a statement made by a deceased person while they were alive, you have to corroborate it with evidence. So you can get into this battle of words. Mom said it's a loan. No, mom told me it's a gift. Who's right? Who's got the paper?
Yeah, well, interesting. You kind of answered the next few questions, but what about the situation? And every so often you hear about this in the news where, an elderly person passes away and they leave their estate to their cat or their pet. and there's I guess they've gone to a lawyer, maybe, or they use the will kit. The cat ends up with the estate. The cat has to stay in the house until its 9 lives are used up. But let's say there's children of this elderly person. What recourse, if any, do they have? Because really, why does a cat need a house?
Yeah, this is a great question. It's one that people threaten. I've heard before, my kids are terrible, I'm leaving everything to the cat. Well, the short answer is you can't give property directly to your pet in your will. The reason is because pets are viewed as property, and property can't receive property. So you can't say, oh, right, my cat gets my house, my cat gets $10,000 a month. You can't do that. However, there is some ability to establish trusts, maybe for the care of an animal, but keeping in mind that I guess that would be a non-charitable purpose trust, and those things have short limited lifespans. So, if you want to make sure that your pet is looked after, that's one thing, but you can't just say, by a stroke of a pen, here's my estate, I'm gifting it to my pet.
Yeah. Well, I tell you, my dog right here, he's more than just a pet, But
oh yeah, they're family. I would love to leave my estate to my dog, but unfortunately, I'll have to come up with a better way.
Okay, but it is a good idea in your will to, like, if you do have a pet, to disclose what you want done with that pet, or who you want the pet to go to.
Oh, sure. Absolutely. And if you're planning to set aside some money for the care of that animal, you might say, I'd like my sister to look after my dog. And for that purpose, I've earmarked some money. Okay. But I couldn't just say to my beloved Australian Shepherd, here's everything. So
enjoy. Okay.
Yeah. Great question.
Thanks. Is there any other situation that we haven't covered yet that comes to mind that you could maybe tell us about?
Yeah, I think the situations that I see the most frequently that are the most problematic are do-it-yourself wills that are not done properly. So again, if you're going to do it by hand, or if you're going to do your own will, you have to make sure you still meet the validity requirements. So in those cases, that would be like the will kit where you sign without 2 witnesses. That's not a valid will. On the other hand, a scribbled piece of paper on the kitchen table that you've dated and signed and that's all in your handwriting is. So DIY wills gone wrong, that would be one of the biggest problems. Joint accounts, and then gifts. Undisclosed gifts, people who give things away but don't really make clear what they're doing. I think a lot can be resolved by documenting your intentions, including by a will, good communication in your family if you have the kind of family dynamic to do that. And really, there's no substitute for proper planning.
Yeah, absolutely. I just have one last question.
Sure.
Yeah, let's say that you're my sister, or even my friend, and I'm writing a letter to you, and in my letter I say, you know what, upon my death, I think this is what I want to happen to my assets, my estate, and I sign the letter because I'm mailing it to you, and I've dated it. Would that be a valid will? Is that a holograph will in a sense?
Well, so the key element that would be missing there is the dispositive intent. So any writing that's a great example. So, it'd be like sending a postcard and saying, I bought these beautiful things that made me think of you. Maybe I'll give them to you someday. It's not firm in your mind. It's not an expressed and final statement of your testamentary wishes. So that letter, I think you'd have a really hard time convincing a court that it could be a valid will, because when you're writing your friend a letter, you probably aren't setting out your fixed and final intent with respect to the disposition of your property. So I would say that, unless obviously there's circumstances where maybe that would be true. And sadly, there are stories of suicide notes also containing elements of a will. But a letter to a friend like that, like what you've described, most probably wouldn't be.
Okay. You just mentioned suicide. if somebody leaves a suicide note and says, I want to leave everything to so-and-so, is that a valid will?
It can be. It can be, assuming that the requirements of a holograph will are met. So again, signed, dated, with the final expression of your testamentary intentions. So, questions of capacity can come up. What state of mind were you in at the time? But it is possible, and it has happened, that a suicide note has been upheld as a will.
Okay, interesting. All right, well, Shannon, it looks like we're just about out of time. Thank you very much for being our guest and for providing a lot of insight and value. I know you're very busy this time of year, so I really appreciate you stopping by.
Well, thank you for having me, Gary, and thank you very much for the conversation today.
Well, thank you. And Shannon, if our audience want to get in touch with you, how can they do that?
That would be great. People can reach out to our firm. Our website is carscallen.com, carscallen.com, and I can be reached at james@carscallen.com.
Okay, great. Well, thank you again. And thank you to our sponsor, Customplan Financial Advisors. Customplan is an award-winning MGA that provides exceptional support and resources to the independent financial advisor. Please visit their website at customplanfinancial.com. This podcast is available on YouTube, Spotify, and at financialpodcast.ca. To be notified directly when new podcasts are available, please subscribe by visiting financialpodcast.ca. If you have an idea for a podcast or know of someone who'd make a great guest, please email me at info@financialpodcast.ca. We would also love to receive your feedback. Thank you again, Shannon, for being our guest, a great guest. And to everyone else, have a fabulous day.
The views expressed here are those of the participants and not those of Customplan Financial Advisors, Inc., its affiliates, or subsidiaries. This is not intended to serve as a complete analysis of every material fact regarding any company, industry, or security. This presentation may contain forward-looking statements. Investors are cautioned not to place undue reliance on such statements, as actual results could vary. This site and podcasts are for general information purposes only and does not constitute investment advice and is not intended as an endorsement of any specific investment product or service. Individual investors should consult with an investment professional about their personal situation. Past performance is not indicative of future results. If you are unsure about what is the best course of action for you in your financial planning, then we suggest you consult a fee-based independent financial advisor or get in touch with us to discuss your individual situation. Our phone number is 604-687-7773.